Title II. Incorporation and Organization of Private Corporations. Section 10. Number and qualifications of incorporators. Any number of natural persons not less than 5 but not more than 15, all of legal age and a majority of whom are residents of the Philippines, may form a private corporation for any lawful purpose or purposes. Each of the incorporators of a stock corporation must own or be a subscriber to at least one share of the capital stock of the corporation. Section 11. Corporate term. A corporation shall exist for a period not exceeding 50 years from the date of incorporation unless sooner dissolved or unless said period is extended. The corporate term as originally stated in the Articles of Incorporation may be extended for periods not exceeding 50 years in any single instance by an amendment of the Articles of Incorporation, in accordance with this code, provided that no extension can be made earlier than 5 years prior to the original or subsequent expiry dates unless there are justifiable reasons for an earlier extension as may be determined by the Securities and Exchange Commission. Section 12. Minimum capital stock required of stock corporations. Stock corporations incorporated under this code shall not be required to have any minimum authorized capital stock except as otherwise specifically provided for by special law, and subject to the provisions of the following section. Section 13. Amount of capital stock to be subscribed and paid for the purposes of incorporation. At least 25% of the authorized capital stock as stated in the Articles of Incorporation must be subscribed at the time of incorporation, and at least 25% of the total subscription must be paid upon subscription, the balance to be payable on a date or dates fixed in the contract of subscription without need of call, or in the absence of a fixed date or dates, upon call for payment by the Board of Directors, provided, however, that in no case shall the paid-up capital be less than 5,000 pesos. Section 14. Contents of the Articles of Incorporation. All corporations organized under this code shall file with the Securities and Exchange Commission Articles of Incorporation in any of the official languages duly signed and acknowledged by all of the incorporators, containing substantially the following matters, except as otherwise prescribed by this code or by special law. 1. The name of the corporation. 2. The specific purpose or purposes for which the corporation is being incorporated. Where a corporation has more than one stated purpose, the Articles of Incorporation shall state which is the primary purpose and which are the secondary purpose or purposes, provided that a non-stock corporation may not include a purpose which would change or contradict its nature as such. 3. The place where the principal office of the corporation is to be located, which must be within the Philippines. 4. The term for which the corporation is to exist. 5. The names, nationalities and residences of the incorporators. 6. The number of directors or trustees, which shall not be less than 5 nor more than 15. 7. The names, nationalities and residences of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. 8. If it be a stock corporation, the amount of its authorized capital stock in lawful money of the Philippines, the number of shares into which it is divided, and in case the share are par value shares, the par value of each, the names, nationalities and residences of the original subscribers, and the amount subscribed and paid by each on his subscription, and if some or all of the shares are without par value, such fact must be stated. 9. If it be a non-stock corporation, the amount of its capital, the names, nationalities and residences of the contributors and the amount contributed by each, and 10. Such other matters as are not inconsistent with law and which the incorporators may deem necessary and convenient. The Securities and Exchange Commission shall not accept the Articles of Incorporation of any stock corporation unless accompanied by a sworn statement of the treasurer elected by the subscribers showing that at least 25% of the authorized capital stock of the corporation has been subscribed, and at least 25% of the total subscription has been fully paid to him in actual cash and or in property the fair valuation of which is equal to at least 25% of the said subscription, such paid-up capital being not less than 5,000 pesos. Section 15. Forms of Articles of Incorporation. Unless otherwise prescribed by special law, Articles of incorporation of all domestic corporations shall comply substantially with the following form. Section 16. Amendment of Articles of Incorporation. Unless otherwise prescribed by this code or by special law, and for legitimate purposes, any provision or matter stated in the Articles of Incorporation may be amended by a majority vote of the Board of Directors or Trustees and the vote or written assent of the stockholders representing at least 2/3 of the outstanding capital stock, without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code, or the vote or written assent of at least 2/3 of the members if it be a non-stock corporation. The original and amended articles together shall contain all provisions required by law to be set out in the Articles of Incorporation. Such articles, as amended, shall be indicated by underscoring the change or changes made, and a copy thereof duly certified under oath by the corporate secretary and a majority of the directors or trustees stating the fact that said amendment or amendments have been duly approved by the required vote of the stockholders or members, shall be submitted to the Securities and Exchange Commission. The amendments shall take effect upon their approval by the Securities and Exchange Commission or from the date of filing with the said commission if not acted upon within 6 months from the date of filing for a cause not attributable to the corporation. Section 17. Grounds when articles of incorporation or amendment may be rejected or disapproved. The Securities and Exchange Commission may reject the articles of incorporation or disapprove any amendment thereto if the same is not in compliance with the requirements of this code, provided, that the Commission shall give the incorporators a reasonable time within which to correct or modify the objectionable portions of the articles or amendment. The following are grounds for such rejection or disapproval. 1. That the Articles of Incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. 2. That the purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. 3. That the treasurer's affidavit concerning the amount of capital stock subscribed and or paid is false. 4. That the percentage of ownership of the capital stock to be owned by citizens of the Philippines has not been complied with as required by existing laws or the Constitution. No articles of incorporation or amendment to articles of incorporation of banks, banking and quasi-banking institutions, building and loan associations, trust companies and other financial intermediaries, insurance companies, public utilities, educational institutions, and other corporations governed by special laws shall be accepted or approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency to the effect that such articles or amendment is in accordance with law. Section 18. Corporate name. No corporate name may be allowed by the Securities and Exchange Commission if the proposed name is identical or deceptively or confusingly similar to that of any existing corporation or to any other name already protected by law or is patently deceptive, confusing or contrary to existing laws. When a change in the corporate name is approved, the Commission shall issue an amended certificate of incorporation under the amended name. Section 19. Commencement of corporate existence. A private corporation formed or organized under this code commences to have corporate existence and juridical personality and is deemed incorporated from the date the Securities and Exchange Commission issues a certificate of incorporation under its official seal, and thereupon the incorporators, stockholders, members and their successors shall constitute a body politic and corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with law. Section 20. De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code, and its right to exercise corporate powers, shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. Section 21. Corporation by estoppel. All persons who assume to act as a corporation knowing it to be without authority to do so shall be liable as general partners for all debts, liabilities and damages incurred or arising as a result thereof, provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use as a defense its lack of corporate personality. On who assumes an obligation to an ostensible corporation as such, cannot resist performance thereof on the ground that there was in fact no corporation. Section 22. Effects on non-use of corporate charter and continuous inoperation of a corporation. If a corporation does not formally organize and commence the transaction of its business or the construction of its works within 2 years from the date of its incorporation, its corporate powers cease and the corporation shall be deemed dissolved. However, if a corporation has commenced the transaction of its business but subsequently becomes continuously inoperative for a period of at least 5 years, the same shall be a ground for the suspension or revocation of its corporate franchise or certificate of incorporation. This provision shall not apply if the failure to organize, commence the transaction of its businesses or the construction of its works, or to continuously operate is due to causes beyond the control of the corporation as may be determined by the Securities and Exchange Commission.